Wendy Johnson. I'm an attorney for OSPR Legal. I've been with the department for close to 15 years, not quite as long as Randy back there, but I'm also not as old.
Nice.
You didn't hear that, right? Can everybody hear me okay, or should I turn this on? You good? Okay. I prefer that this be more of an interactive session, so if any of you have any questions as I'm going through the presentation, don't hesitate to ask and we can just talk about it. I don't think that I will take up an entire 45 minutes. That would be just too much to talk about legal stuff. So let's get started. I don't know who put that yawn in there. I think this is exciting stuff. But basically, Lempert-Keene is our authority that OSPR uses. It established our office. It also has established some mandates for our administrator. So the administrator is appointed by the governor. So our current administrator is Thomas Cullen, and he was recently appointed by Governor Brown. He's awaiting Senate confirmation. But the OSPR Act essentially just, requires various mandates with respect to contingency planning. So whenever a vessel comes into the state, they have to have a plan of action if they have a big oil spill. Certificates of financial responsibility. That's the thing that everybody carries in their car every day. It says you're financially viable to pay for an accident, something were to happen. And then it also imposes requirements on the administrator, certain things that he has to do. It also has created criminal, civil, and administrative authority for our office. So if an incident does occur, then there's some authority, depending on the facts and circumstances, to pursue. Generally, there are three components of a pollution case. One would be penalties, another would be natural resource damages, and then the other would be costs. And depending on whether there was some egregious conduct or let's say it was an accident, then there may be some other requirements with respect to improving maintenance or operation, training, something like that. But this act essentially gives us the authority to pursue all of that. So the administrator has the primary authority to direct direct any response efforts on behalf of the state. But his authority is not absolute. There's a provision in Lempert-Keene that says that he needs to coordinate with the federal on-scene commander as well. So, it's definitely supported by statute that the administrator needs to be coordinating with the other key players involved in the response effort. The administrator also is required to be present at any spills, oil spills in marine waters over 100,000 gallons. And then the administrator also has to determine the cause of the spill as well as the amount that was spilled. And I'll get into that in a bit as to how that's done. Any questions so far? Okay. So the Act applies to any oil spills over 42 gallons that occur in marine waters. If the spill if it's an oil spill, actually, this has been expanded. In 2007, it was expanded to include inland waters as well. So any oil spills over 42 gallons in either marine or inland waters. Now, sometimes our department responds to pollution events involving dairy waste or shampoo or sediment or something like that. So when our department responds to those types of pollution events, then the Fish and Game Code applies. As well as any oil spills under 42 gallons. So that 42 gallon is the trigger for Lempert-Keene and OSPR's authority. So the administrator is the state incident commander. A lot of you, I've noticed, you're very apprised of the entire ICS structure. Looks like you have more training than I in that. But basically, the ICS is comprised of three parties, essentially. You have the federal component, the FOSC, the state on-scene commander, and then also the responsible party. So the three are supposed to be coordinating to work together to respond to any spills. So the administrator also has authority to respond to inland pollution events, and that was mandated or delegated pursuant to the Fish and Game Code. Unfortunately, that delegation did not come with any funding, so it's essentially an unfunded mandate. But in what we're doing currently, since we no longer have an inland pollution program because we have no funding for it, our regions are responding to inland pollution events that are under 42 gallons of oil or something other than oil. So dairy waste, sediment, all that other stuff. But OSPR will serve as an advisory capacity if the regions need any assistance with that. Fish and Wildlife, I'm not sure if you're aware we changed our name recently. We used to be Fish and Game, but effective January 1st, now we're the California Department of Fish and Wildlife. And we're the trustee for fish, wildlife, and plant resources. So, and what that means is essentially the people of the state have entrusted us to take care of those resources. So we try to protect them, enhance the resources and restore where appropriate. Okay.
Do you know what motivated the change from Fish and Game to Fish and Wildlife?
Do I know what?
What motivated the name change?
Oh my goodness, I think it was, the department went through a public scoping section or session, and I think that the public felt that the name, the Department of Fish and Game, did not adequately characterize all that our department does, because game apparently is more representative of hunting and fishing, but of course we do regulate that, but they felt that Fish and Wildlife just presents this notion that we're just more protective of the fish and wildlife resources as opposed to being hunting and more facilitating for the hunters and anglers. Is that accurate?
Yes.
Okay.
Yes, ma'am.
Question related to the division of responsibilities and authorities. Under federal law, Coast Guard is responsible for the maritime zone cleanups, and EPA is responsible for cleanups. I know there's a Cal EPA as well.
Right.
So I guess my question is, it sounds like OSPR is responsible for both cleanups as the state, not for the inland and the maritime. So there's no real role for cleanup responsibilities for Cal EPA.
Cal EPA is more of a regulatory entity. So I know that the water board does get involved in pollution events. So the question was, what is EPA's role? Because on the federal side, the Coast Guard will respond to maritime pollution incidents, whereas EPA will respond to inland pollution incidents. So for us in the state of California, the Department of Fish and Wildlife, OSPR is the lead response agency to off-highway pollution events. Cal EPA, on the other hand, serves a more regulatory function, in that they will, I do not think that they may have a handful of sworn peace officers, but that's not their primary function, and they're more after the fact. So
you would never see a Cal EPA as a state on-scene coordinator for inland stuff?
No.
Or would it always be Oscar?
No, it would always be our department. Yeah. But we do coordinate with the water board quite often. For instance, there's some counties where we do not have very proactive prosecutors, whereas the water board has an amazing administrative enforcement. They have amazing administrative enforcement provisions. So we coordinate with them to effectuate some type of enforcement where we may not have a district attorney that's willing to do so. So we
Cal EPA and the water board are the same.
Yes, so the water board is within Cal EPA. Yeah, so we do coordinate with the EPA agencies.
Just to kind of follow up on that, we had a major it even showed up here at pipeline burst out in Mississippi Marsh. And so OSPR and Coast Guard came out and they handled the response. And then afterwards, Cal EPA, State Water Board, and Regional Water Board came through and with the local county oversaw the cleanup of that. So that's really where we get more remediation. Yeah.
And then also, future, I know that the water board will require dischargers to provide plans to minimize future pollution events, or plans to indicate how they will respond to future incidents. But yes, definitely, they usually come in kind of after the fact. And they are actually, the water board has become a little more proactive with respect to getting out there when the incident is occurring, just within the last couple of years, whereas before we would never see that.
So the 42 gallons, the state can't do any enforcement unless it's a barrel of oil in the water?
We can pursuant to the Fish and Game Code.
Okay.
Yeah. So Fish and Game Code section 5650 makes it unlawful to discharge anything from petroleum to any solid or waste from a factory, or anything that's deleterious to aquatic resources. So we use that provision a lot because it can encompass a lot.
So if I have a release out in the Delta or whatever, and I've got 60 gallons more oil, I can expect OSPR?
Yes. If it's dairy waste, then you could probably expect somebody from the region. And that's new. That's relatively new, just within the last several months. Just because of the state of our inland pollution fund. Okay. So Lempert-Keene provides that the administrator has the authority over the use of certain response methods, but again, there's that consultation requirement with the FOSC. The administrator's authority is not absolute with respect to that. Volunteers can be a significant issue in response efforts. The responsible party and our department, we're a little hesitant to use volunteers just because of the liability risk associated with using them. They are employees of the state for workers' compensation purposes, but there are certainly activities that volunteers can do during the response. And we have a volunteer coordinator who has worked with our responders to identify certain activities that volunteers can safely perform to, which, minimizes our liability, but yet there's intense pressure to use volunteers. So, we try and satisfy the people that really want us to use the volunteers, but in a way that it's not going to subject our department to legal exposure, or at least minimize that. But it was a huge issue in Costco Busan, and it can be a significant issue. But I think that our department, since Costco Busan, has worked to have a plan in action for any future incidents.
Just a question, and I'm not a legal person, but that seems like hyper vague. For instance, there's no mention of scope of training that the volunteer might have had, or the requirement for DSW swearing for the workers' comp thing.
Mm-hmm.
Am I is this just the way it is, or do those things considerations, or is there guidelines that augment this at all?
There are no regulations. No state regulations with respect to using volunteers. So if the state retains somebody as a volunteer, and I know that we do so for the Oil Wildlife Care Network, if they're a volunteer on our books, then essentially they're a state employee for workers' comp purposes. I don't know. I think it would be hard since it's in statute. I mean, it's clear that the legislature, when they drafted the statute, they wanted volunteers to have that protection. So if we were to request them to waive it, we might get into a little bit of trouble for that, just because it's so contrary to what's already in the statute.
Can the RP assume the volunteers?
Yes, but sometimes generally they don't want to because of the liability
But on
risk.
a BP scenario or somewhere where you have a large response, would they be? Is that something we would consider?
Oh, definitely. We consider all options, and it basically boils down to your cost-benefit analysis. So that if the cost of using the volunteers outweighs the benefit, then it's a consideration. But thankfully, we're not alone in this. The legal teams are working together. The attorney for the FOSC and federal trustees, as well as all the state attorneys and the RP attorneys, we coordinate on these issues and try and work out some resolution to, facilitate the use of volunteers, or whatever the issue may be. We just try to facilitate it.
There is in Costco Busan where some of the local counties work very closely with OSPR to develop the volunteer plan for non-wildlife. And it does lay out the requirements on the South State's Disaster Service Worker Program and the considerations that need to be made at the Unified Command about whether or not volunteers are going to be utilized and different opportunities that they might be utilized for. And so hopefully, we won't ever be in a position where we are pressured to do that again as happened in Costco Busan. But there is a plan, and it does, lay out how people have to get sworn in, authorized, and how they're covered under the disaster service program.
Yeah, I have not seen that plan. I just know that Cindy Murphy was working on one, and that we have something in place. So that's great.
Section 9000, I think, of the ACP.
Oh, okay.
So it's been accepted.
Okay, so just for the northern, just for that region.
Well, there is also one for the Tennessee, right? It's also been accepted.
There is one for the National Institute that was approved by last year.
Yeah, the National Response Team brought out the ACP. We're incorporating the state's volunteer plan into the regional incident plan.
Oh, okay.
That's going to be captured for all three sectors.
Okay, great. Very good. So there you go. See the benefit to having the interactive discussion. Okay, so where does legal fit into the ICS? We are a little dotted line off of the state on scene commander. We are actually outside of the ICS structure, and the reason for that is we want to retain our confidentiality privilege to have candid communications, with our client. If we were a part of the ICS, then any discussions would be, written down and it's subject to documentation, and so we're outside. Our assistant chief counsel put this in. He thought it was funny and requested I leave it in. But there we go. Okay, so with respect to legal response, I'm sure there's always the question, what are the lawyers doing? What are all those lawyers doing? So really our goal is to facilitate the response effort and assist with any legal issues that come up. MOUs are one way to do that. We have, OSPR probably has 100 MOUs with other federal agencies, state agencies, addressing a whole myriad of issues. Something comes up in a spill, let's say something came up in a spill in 1990. So somebody drafted an MOU to deal with it to use in the future. So for instance, we have a decanting MOU with the water board that provides that we don't need a permit whenever, decanting is occurring. Whereas before, there must have been some time where the water board said, oh, you need a permit if you're going to be decanting. So we have an MOU to address that now. So we don't need a permit. We have a lot of permits with Fish and Wildlife Service, coordinating the natural resource damage assessment process, or, there's some response MOUs pertaining to certain species. It just all depends. It's very fact and action specific. And then we have one with toxics as well, pertaining to, characterization. Permits. Permitting is always an issue. Do you need a permit during emergency response? It's something our office is grappling with currently, especially with respect to the California Endangered Species Act. Because if you look at the act itself, there's no emergency take provision. Everywhere else, there's some emergency provision, but the California Endangered Species Act does not have one. So what we have been doing is working with our regional staff to attain the necessary permits if it's likely that the response effort is going to, take a California endangered species. The Federal Endangered Species Act, I believe that there's an emergency provision within the Federal Act. So if we have a dual listed species, we have some critter that's on both lists, then we would want to get a federal permit or have the RP get a federal permit, and then the state could just do a consistency determination. Yep, our provisions would be consistent with what Fish and Wildlife Service is doing.
Yeah, there's an MOA between Department of Interior, which where Fish and Wildlife Service is, and Department of Commerce, which is where NOAA is, and EPA and Coast Guard for how to go through emergency consultations to satisfy Section 7 requirements in the Endangered Species Act for anyone who talks about that whole process. We basically make sure that their input is provided to the command and considered and become part of the work plans, and that the document is sufficiently so that when we finish the response, that's when we do the paperwork exercise, the paperwork consultation process.
Yes.
So the consultations are the pull-up operation.
Right. Yeah, and that's great. I wish we had that on the state side, and And perhaps that's why it's never really been an issue when responding to marine incidents. But we faced a couple of inland responses where we do not have, that type of emergency provision. And so we've had to go through the permitting process. Thankfully, we can do it simultaneous to the response so that it doesn't hinder or delay the response effort. There's also California State fully protected species as well, found in the Fish and Game Code. And I always dread the fully protected species questions because the authority is absolute, and the department simply cannot authorize take of fully protected species. So it really puts us into this legal quandary. We have to get really creative to, try and facilitate the response, but yet comply with our own statute. So that's permitting. Any questions about that? Okay. Coordination with the RP. We're always coordinating with the RP, primarily obtaining documents from the responsible party. So, for instance, when the Kinder Morgan incident occurred, we were very interested in training records, maintenance records, coordinating interviews with witnesses, that type of stuff. The oil spill prevention specialists generally coordinate with the responsible party to quantify the amount of product that was discharged and what was recovered. And then also press releases through the JIC. We're also coordinating with the RP on that. Cleanup and contractor issues. So in the event that you have a discharger or responsible party that is just not willing to clean up what they spilled, then we have, or let's say it's an ongoing spill and they're not willing to abate it or stop it, then we have cease and desist order authority. So basically it's just an order from the administrator. It says you need to stop that. And then also cleanup and abatement order authority as well. If we issue those orders and the discharger doesn't clean up or take appropriate action, then our office can just take over the spill and take appropriate action to remediate the impacts and seek the costs associated with that from the responsible party. However, the responsible party is also subject to our overhead rate, which is 30% right now. So usually they're pretty motivated to, do the right thing. During response, we're reviewing a lot of different documents, incident action plans, press releases. We're looking at every decision with respect to whether or not it's going to create liability for our department. Unfortunately, we live in a very litigious society. So, there are people out there that just want to bring lawsuits for whatever reason. And so we're always looking at every decision with respect to, okay, who's going to sue us for that decision? And, what's the risk? Do we have a valid defense? And what's the benefit? The benefit outweighs the risk. Of course, we're going to do what we need to do to protect the resource. But so we're always looking at potential liability, especially with respect to health and safety issues. The designation of responsible party, that is something that's mandated by the Act. It always kind of catches the responsible party off guard when we issue a designation of responsible party. And it's basically a letter from the administrator that says, we've designated you the responsible party and you need to establish a claims procedure. And really, it's just something that's mandated by the administrator pursuant to the Act. It's something that we have to do. It's kind of a procedure. If the responsible party doesn't establish a claims procedure within a certain amount of time, then the administrator is required to. So that's, one of the things that we're usually drafting pretty early on.
Could you give an example of a circumstance, hypothetical or real, where, a designated RP didn't roll over and stipulate, and they said, no, that buoy shouldn't have been there, or that bridge moved and jumped in the way, or something like that?
Not really. Maybe after the fact. I've had situations, I actually had one in the Central Valley recently where the investigative report had, identified a discharger, and they were very proactive in cleaning everything up and taking appropriate action. But then when they got our cost bill, they said, no, it wasn't us. We didn't do it. We were just being responsible. So it comes up not very often though, but it's always an awkward situation when you're coordinating, you're working as a team, amongst the federal entities and the responsible party to then provide this designation. The responsible party kind of thinks, well, I've been proactive, I've been responsive, and then that's generally the case, but they just kind of sometimes don't understand where that's coming from.
Do we get confused as responders to that term, responsible party, which is a legal term? The reality is, oftentimes, the person who spills the oil isn't necessarily responsible. Like, you can have a tanker truck driving down the freeway, and a truck driver is on the wrong side of the freeway,
right,
heading towards his tanker truck. It's the tanker truck spills. The tanker truck is still the responsible party. It's really just it's a legal thing after the matter on who pays, but that tanker truck will still be RP. And from a responder standpoint,
so the carrier
is
always the RP,
right,
regardless of fault.
The owner of the product.
Yeah.
Copy that. Thank you.
Yeah.
Whoever owns it, and then it's for their attorneys after the fact to decide who's at fault.
And I've had that situation actually come up in this area, and they may clean it up, and we'll request our costs from them as the owner of the product. But most generally, I would imagine that they would then file a claim against the individual who actually caused the accident, their insurance. So, they have attorneys as well, and it all gets sorted out. But thankfully, we don't have to sort that out before we're responding. So it's very clear in statute who needs to take action. Again, so I already talked about this. The administrator is required to determine the cause and the amount of the discharge. We have an investigative team whenever an incident occurs that goes out. So we have a warden, our enforcement component. They have search authority, and then also they're California State Peace Officers as well. So they're going out, they're determining what happened. The biologist, and I'm probably oversimplifying this, but the biologist will assess the injuries to the resources as a result of the spill, take samples, assist in developing sampling plans, as well as identifying appropriate response measures that are most protective of the resource. And then the oil spill prevention specialist, again, they do a host of things like they assist in determining the cause. So they work together with the warden to determine what happened. They prepare quantifications both of what was spilled and then also what was recovered. And then the response attorney will advise, sometimes all of them, depending on the size of the incident. California has regulations on how to quantify oil and water. So basically it just identifies gauging methods and it has a list of, the calculations to use. Anybody's interested in looking at those, they're in Title 14, California Code of Regulations, 877.3. Also, all of our statutes and regulations are on our website. If you ever want access to them, our legal assistant has prepared a compendium of all of the state pollution laws, which is on our website. So if you want to access it, it's very helpful. It has Lempert-Keene, and then also provisions of the Fish and Game Code that we use as well. So quantification of oil and water is different than quantification of oil and sediment. You use an entirely different method. There's an entirely different set of regulations for determining how much oil is in sediment. So does anybody have any ideas of why it's so important to determine what's been recovered? Yes?
Because the balance might be causing harm to the environment.
Yeah?
Also, you
Yeah, that's,
you would be billing by the number of barrels or whatever.
there you go. Ding, ding, ding. So yeah, definitely. When we seek penalties later on, the amount of the penalties is offset by whatever has been recovered. So there are provisions in both the Fish and Game Code as well as the government code that allow for penalty offset. So it's important from our perspective to know how much was spilled, how much was recovered, because of course that's important information with respect to how effective the response was, what are any future impacts with respect to leaching or anything like that. Is the remainder just evaporated? We just want to make sure that we get as much as we can. But of course, the lawyers are always looking at the penalty offset.
Is there like a temporal element too, in terms of how quickly it's recovered? Because I can imagine you might recover a certain amount, but there could have been damages done along the way if it took days to recover.
I think that's definitely important, with respect to how effective the response was and potential future impacts of anything that's lingering out there. But it doesn't come into play in the recovery, the penalty offset. That could get really complicated. So I just talked about what the response attorney does, but there are other attorneys. I mean, I'm one of, I think, 5 or 6 in our office. If it's a large-scale incident, we'll sometimes have 3 attorneys working just one incident. 1 assisting with the response, 1 assisting with the investigation. 2 are kind of separate, because generally the investigative team is not a part of the ICS in response. They're off doing their investigations separately. And then 1 that facilitates the natural resource damage assessment. So I think that Dr. Hampton is coming later on to talk about natural resource damage assessments, but basically natural resource damages are the interim loss to the resource from the time that the impact occurs to the time that it's fully recovered. We have economists on staff who place a value on that interim loss, and they do that by looking at 3 factors. The length, the injury, the duration, spatial extent, and which one am I missing? Okay, natural resource damages, 3 factors. Duration, how long it will take for the resource to recover. Spatial extent, degree, the degree of injury. So if you have 100% loss and it's going to take 10 years to recover, all of that information is factored in and our economists, I'll let Steve tell you. The math is certainly over my head there. But the natural resource damage assessment attorney, generally it's Kathy Baru Slater, who works in our office. She's done all of the large NRD cases. But a lot of her time is, coordinating with other federal trustees, as well as the RP. Sometimes the damage assessments are done cooperatively. Can anyone think of why we would want to do a cooperative assessment with an RP?
So you can actually get claims out of it instead of just get stuck in litigation forever.
Exactly. So if you can get buy-off from the responsible party in the beginning, and you all agree on how the assessment is going to occur, then it just avoids litigation down the road. Litigating the manner in which those damages were assessed. It also avoids a duplicative effort. Otherwise, you have every, natural resource trustee going out preparing their own damage assessments. So you have thousands of consultants. So it's just better to coordinate on all of that. And then once the damages are recovered, the damage assessment attorney will work on a trustee council to implement the restoration projects, which can be very daunting. Lots of property transactions, state contracting, all of that stuff. Cost recovery, in California, the polluter pays, not the taxpayer or the angler or anyone else. So we always try to obtain our costs whenever we respond to a pollution incident. This is just the authority that we use. Okay, almost there. So, believe it or not, we're here to help. We're not, the lawyers are not the problem-making obstructionists. It's our goal to try and facilitate the response, and we'll listen to the problems that are coming in, look at any constraints, and try and work around them. But again, every case has such a unique set of facts and circumstances. We have to evaluate on a case-by-case basis. You can't apply what you did in Kinder Morgan to some future spill. It's all very unique. It's all evolving. So yes, definitely coordinate with your legal team, whether you're state, federal, responsible party, whoever you may be. It's important to coordinate, and we're all working together to try and work through these issues. And does anybody have any questions?